Tonight we're going to walk through one of the most explosive scenarios you can imagine in American politics. A sitting federal judge facing an impeachment push on a 72-hour clock amid claims that no judge has done anything like this in 249 years of American history. Whether you're watching this during a real impeachment scare or simply trying to understand what such a showdown would look like if it ever happens, the core questions are the same. What does it actually mean to impeach a federal judge? How fast could it realistically happen? What would make it truly unprecedented? And what would it do to the balance of power in the United States if Congress decided to pull that trigger in just 3 days? To answer those questions, we have to cut through the noise and go back to first principles. Federal judges in the United States do not serve at the pleasure of any president or Congress. They are appointed under Article 3 of the Constitution, and once confirmed by the Senate, they hold office during good behavior. In practice, that means life tenure. They do not stand for re-election. They are not subject to routine performance reviews. There is no confidence vote. There's only one constitutional mechanism to remove them: impeachment. Impeachment is the same basic process used for presidents and other civil officers. The House of Representatives has the sole power to impeach, which functions like an indictment. Articles of impeachment are drafted, debated, and then voted on. If a simple majority of the House votes in favor, the judge is impeached. The process then moves to the Senate, where a trial is held. Conviction and removal from office require a 2/3 supermajority of senators present. It is meant to be a grave, extraordinary remedy, not a routine political tactic. The Constitution says judges, like presidents, may be impeached for treason, bribery, or other high crimes and misdemeanors. Those last 4 words have been debated endlessly. They do not refer only to statutory crimes. They are best understood as serious abuses of public trust, conduct that strikes at the integrity of constitutional government itself. When it comes to judges, that traditionally has meant corruption, clear dishonesty, or conduct so unfit that it makes continued service on the bench incompatible with the office. Historically, impeachment of federal judges has been rare. Over more than 2 centuries, dozens of judges have been investigated or threatened, but only a small number have actually been impeached by the House, and even fewer have been convicted and removed by the Senate. The pattern is consistent. When judges have been impeached, it has almost always been for things like bribery, tax fraud, perjury, criminal convictions, or obvious abuse of their office for personal gain. What you do not see, at least in the final outcome, is judges being removed simply because Congress intensely disliked their legal reasoning. That distinction goes back to one of the most important early impeachment episodes, the case of Supreme Court Justice Samuel Chase in 1804. Chase was a staunch Federalist, deeply hostile to President Thomas Jefferson and his allies. Jeffersonians in Congress accused him of partisan behavior on the bench and impeached him. But when the case reached the Senate, enough Jeffersonian senators balked at the idea of removing a justice over his judicial opinions, however partisan they seemed. Chase was acquitted. And that acquittal is widely seen as a foundational moment for judicial independence in America. It established a norm. Bad judging, or even openly political judging, is not by itself an impeachable offense. That's why claims of a 249-year first should immediately prompt a question. Are we really talking about conduct more extreme than bribery, fraud, or criminal abuse of office? Or are we talking about the substance of controversial rulings being repackaged as misconduct? Those are very different things. One goes to the integrity of the office, the other goes to disagreements over how the law is interpreted. If impeachment drifts from the former into the latter, we're not just disciplining judges, we're reshaping the role of the judiciary. Now add the 72-hour clock. On paper, the Constitution doesn't set a timeline. If the House majority wants to move in 3 days, and it is willing to compress or bypass hearings, it can try, but speed has consequences. To credibly claim you are wielding impeachment responsibly, you would need to show that you gathered evidence, evaluated it against historical standards, allowed some form of response from the judge, and held at least minimal hearings. In most real-world circumstances, doing all of that in 72 hours is implausible. A rush timeline usually signals not just urgency, but political calculation. A belief that emotions are high, the base is energized, and delay might erode support. Supporters of a rapid impeachment will often insist this is not about punishing a judge for an unpopular ruling. They will argue that the judge has crossed a qualitative line, defying higher courts, ignoring clear precedent, coordinating with political actors, or otherwise abandoning the law. If that description is accurate and supported by evidence, then impeachment can be a legitimate remedy. A judge who openly refuses to follow binding appellate or Supreme Court decisions is claiming a kind of personal sovereignty that no Article III judge possesses. That is not judicial independence. That is defiance of the judicial hierarchy. But in practice, the facts are rarely that clear. Typically, you have two competing narratives. One side paints the judge as principled, applying the law as they see it, and being punished for displeasing powerful interests. The other side paints the judge as a partisan in a robe, twisting the law to reach ideologically convenient results and hiding behind judicial independence as a shield. Which story takes hold depends heavily on how the media, political leaders, and opinion makers frame the conflict. That's where impeachment as a blunt instrument becomes especially dangerous. Once impeachment is used in a highly charged, rapid-fire context that looks even partly like payback for ideological decisions, it becomes easier to use again under similar circumstances. If one party impeaches a judge for what it calls lawless behavior, the other party can adopt the same rhetoric when it regains power and targets a judge on the opposite side of the ideological spectrum. That is how tit-for-tat escalation turns impeachment from an extraordinary remedy into a partisan weapon. We've already seen a version of this in judicial confirmations. One side deploys unprecedented obstruction, the other responds in kind when it has the numbers, citing what was done to its nominees. Norms decay. Written rules remain, but informal guardrails vanish. If that same spiral takes hold around impeachment, judges will increasingly live under an implicit threat. Rule the wrong way in a high-stakes case, and your job may be on the line. That is the opposite of what an independent judiciary is supposed to look like. At the same time, it is also dangerous to drift into a world where judges are effectively unaccountable. Real corruption does happen. Judges can commit crimes, hide conflicts of interest, abuse their power, or so flagrantly disregard legal obligations that their continued presence on the bench undermines public trust. In those cases, impeachment must remain a real, usable tool. The challenge is drawing a line that preserves impeachment for genuine abuses of office while resisting the temptation to deploy it every time a decision enrages a partisan base. So, as you hear talk of an impeachment vote in 72 hours, there are a few questions worth asking yourself. Is the core allegation about conduct corruption, lying under oath, defying higher courts, or is it fundamentally about outcomes decisions that one side cannot tolerate? Has there been any meaningful process, even on an expedited basis? Or did the calls for impeachment erupt immediately after a single ruling? Are there credible voices outside the usual partisan lanes, legal scholars, former judges, or even members of the judge's own ideological camp saying that impeachment might actually be warranted? Or is the lineup perfectly predictable along party lines? Ultimately, this isn't just about one judge. It's about what kind of constitutional order we want to live under. If Congress starts to treat impeachment as a fast-moving partisan tool, judges will feel that pressure. Some will consciously or unconsciously trim their sails, avoiding controversial rulings to reduce the risk of becoming the next target. Others may dig in and become even more combative, deepening the perception that the judiciary itself is just another political battlefield. At a time when trust in institutions is already crumbling in Congress, in the presidency, in the media, the courts have been one of the last branches still viewed by many Americans as at least somewhat above the fray. That trust is fragile. If impeachment of judges becomes routine rather than rare, that remaining reservoir of confidence will evaporate quickly. Once lost, it will be extraordinarily hard to restore. In the end, the question is larger than any single 72-hour vote. It is whether we still intend to be a nation governed by laws and institutions, or whether every tool in the Constitution will be reduced to just another weapon in a permanent political war. How we answer that question in moments like this will shape not only the fate of one federal judge, but the future of the American experiment itself.